So good morning, everybody. I'd like to begin by saying thank you for Equinet for organizing this very important, relevant and timely webinar. This is a very important topic. I've seen that equality bodies have been working quite a lot on this for the past year or more than a year already. And I would like to thank you for inviting me to present the results of our report. So what I would like to do this morning is to introduce our reports, why we decided to do this research, what was the basis for the building of our research, of our investigation, what was the type of use of AI that we assessed from a fundamental rights point of view, what were our key fundamental rights findings, and finally saying a few words about some of our recommendations. So these are the two bases that we took in order to build our research. So as you know, there have been many policy developments in the area of artificial intelligence across the EU institutions. This culminated this week with the most awaited publication of the draft AI regulation, but also at Council of Europe level, at UN level, OECD, at national level. We've seen that there have been quite a number of policy initiatives, legal initiatives that have been produced, published. You can find also on our website, we published an Excel with all of the policy and legal initiatives that we collected from the 27 and including the UK, because we began our research a year ago. And what we've seen is that most of these initiatives raised a fundamental rights issue, but many preferred to look at soft ethical frameworks. The focus on ethics is quite attractive indeed, because it provides a strong selling point. It enhances consumer trust by saying we will focus on ethics, and still it is still seen as a framework that will not stifle innovation and that will protect business models. But when you take ethics in isolation, ethics is voluntary, that cannot be enforced, and they are not standardized. Human rights or fundamental rights, on the contrary, are binding. They put the responsibility on the states. They build on a vast experience with regard to the protection of individuals' rights, and they put the focus on the harm suffered by the individuals, which is why we decided that this analysis on the impact of AI systems on fundamental rights has to be a rights-based approach. The second premises that we took was, so based on our research, we saw that because AI is used in so many different fields, the discussion on AI systems very often led to very generic and abstract discussions. There is very few knowledge and a lack of evidence in relation to fundamental rights. And this is the second decision that we took, was to build this research on an evidence-based approach. The research that we launched a couple of years ago decided to bring these two aspects together as the basis for our analysis. We combine in our research desk research and fieldwork. On the desk research, we made a preliminary analysis of the international legal framework, the national frameworks, because we've seen that there are quite a number of policy legal developments at national level, and that can be sector specific, that can also have an impact on fundamental rights and also support the protection of fundamental rights. And we combine this with desk research, with fieldwork in 5 countries, Estonia, Spain, Finland, France, and the Netherlands, where we conducted 91 interviews with public administration and private sectors that have declared that they use AI systems in their work, and with 10 experts from civil society organizations and one from public institutions, such as data protection authorities, for instance. First question that we had to answer, what is AI? So as you know, there is still no universally accepted definition of AI. Today, rather than referring to concrete application, the definition of AI that we can mostly find reflects the most recent technological development that can cover quite a number of different technologies. For our research, we decided to apply a broad definition of AI, and we referred mainly to the definition of the high-level expert group on artificial intelligence because it was quite broad. We've seen also that the interviewees we spoke to have different way of thinking when we talked about AI systems. When we had to identify use cases to be explored in our research, we decided to focus on two of these: applications that can support decision-making based on the use of data and on machine learning, and application and systems that can contribute to automating tasks that are usually undertaken by humans or that cannot be undertaken by individuals because of their large scale. We focus on analysis on specific use cases. So as I said, we had 91 interviews. In some instances, the interviews referred to different types of AI systems. So we covered more than 100 different types of AI systems. We decided to focus the use cases for the purpose of the fundamental rights analysis on 4 different fields: social welfare, marketing, law enforcement, and health services. So on social welfare, we had example of decision for housing benefits, support to unemployed people. On marketing, we had example of targeted online advertising, targeted emails. Law enforcement, we had, of course, predictive policing about defining crime hotspots, but we also had the use of AI system for risk assessment in relation to domestic violence. In relation to health service, we had image analysis in relation to stroke, cancer detection. We also had other uses such as monitoring of vital statistics. So we decided to focus on these 4 because they are particularly sensitive with regard to fundamental rights, and because 2 of these cover mainly public administration use of AI. So these are social benefits allocation and predictive policing. And the other 2 concern the use of AI by private companies, health services, and targeted advertising. The use of technology described by the interviewee, as I was saying, involved really different level of complexity and automation. Some applications were quite straightforward to understand, and I am not an IT person, so that was quite useful for me. And the other applications used more traditional statistics methods to inform the decisions. We had more complex machine learning methodology, for instance, to feed into forecast statistics for government reports. And we had also some algorithms that had much higher level of complexity, such as deep learning. We saw this for diagnosis support in the area of health. Here it's important to note that these tools still include a high level of human review and therefore do not include a high level of automation. One example that have high complex algorithm and few human review for the output and the decision were in targeted advertising. The figures that you can see on the slide show the word that was the most frequently used to describe the use cases by the interviewee. So for what purpose was AI used? The 2 quotes that you can see on the slide comes from interviews with public administration. The vast majority of respondents across public and private sector mention using AI for greater speed, fewer errors, and cost reduction. In most of the use cases, we had previously individuals that was performing the tasks. So the respondent says that they decided to use AI because it seems to them that it would guarantee fewer mistakes. Some respondents said that they decided to use AI because it could allow them to carry out tasks that humans could not carry due to the large quantity of data that could not be processed by individuals. It's very important to note that in half of the respondents that we interviewed, they said that the use of AI was relevant in order to make decisions. So the single most important reason for using AI was to increase efficiency. Here it's important to note that efficiency alone cannot be a justification to interfere with fundamental rights. So what was the fundamental rights framework that we worked with? Because we decided to assess these use cases from a fundamental rights point of view. So as you know, as equality bodies, the Charter is the cornerstone and the main source of fundamental rights in the EU, including when it comes to the use of AI. There is very important secondary EU law that is safeguarding of fundamental rights, most notably in the area of data protection. We talked already about the GDPR, but also the Law Enforcement Directive and non-discrimination law. EU member states are also party to international human rights treaties, most notably the ECHR, UN treaties. And finally, as I said already earlier, you have national and sector-specific laws that further safeguard the respect of fundamental rights. While we were analyzing the production of legal and policy initiatives by member states, we've seen that most of the member states were still waiting for development at EU level. However, quite a number of these did publish initiatives at national level, generally sector specific, that can have an impact in further safeguarding fundamental rights in the use of AI. So what was the awareness regarding fundamental rights of the respondents? We found that in general, there is awareness regarding the fact that fundamental rights should be protected, but very few detailed knowledge. We found that there is a good knowledge about data protection, but also high level of uncertainty with respect to AI-related provisions from the GDPR. And there is a general awareness about non-discrimination, but here we've seen very different views among the respondents. Another important point to note, the awareness of the fundamental rights was much higher in public administration than in private companies. And I will now highlight a few of these rights. So data protection, as I said, thanks to the GDPR, we've seen that there is quite a high awareness of, quite a good knowledge of the fact that there is a data protection legal framework and this has to be respected. However, there is quite a high level with regard to the lack of clarity and a lack of transparency regarding the use of personal data by the respondents. When it comes to automated decision-making, respondents were very careful, particularly within the public administration, and most of them stated that they believe the law was not entirely clear. Most interviewees in public administration stressed the importance of the human review. However, very few of them described what this human review actually consisted in, and how other information would be used in order to review the outputs produced by AI systems. There was no agreement amongst interviewees with regard to whether the existing legislation is sufficient, but yet there was an agreement on the fact that there is a need for a more concrete interpretation of the existing data protection rules, notably with respect to automated decision making. With regard to equality and non-discrimination, as you know, and as you highlighted also in your report, discrimination is a crucial topic when it comes to the use of AI, because the very purpose of machine learning algorithm is to categorize, is to classify, is to separate. Many interviewees noted that the use of AI in general can discriminate. So there is an awareness on this. But what they said that our AI system does not discriminate. We are not working with an AI system that discriminates. Something that we found also across most of the respondents is a belief that if they exclude information on protected attributes, this will be sufficient to protect against discrimination. So there is very few awareness with regards to the question of proxies. Much of the discussion about discrimination when using AI was linked to biases with respect to ethnic origin, gender, and to some extent age. However, the question of age mainly come in relation to insurance and credit. None of the interviews directly mentioned the rights of the child. And importantly, also, none of them mention issues linked to integration of people with disabilities. That was not raised by none of the respondents. The third fundamental right that I'd like to speak about today is access to effective remedies. Algorithm decision making is quite well known for being opaque. When we talk about data collection, we talk about algorithm training, selection of data for the modeling, the profiling, all the situation around the individual consent, the effectiveness, the error rates of the algorithm, all of this, they're very barely reported in a transparent manner. Yet, preconditions that are necessary for any remedy to be effective in the area of the use of AI system in practice is that everyone needs to be aware when AI is used, and that everyone needs to be informed of how and where to complain. What did we find? We found that there is some degree regarding the awareness that people have the right to complain, but this awareness focuses on the existence of normal procedures, so not specifically related to AI cases. Interestingly, some respondents said that they were considering developing other ways in order to allow individuals to complain. Very few organizations interviewed received any complaint challenging the use of AI. So to ensure access to effective remedy, transparency and access to information is crucial, including the need to explain decisions. I talked about 3 specific fundamental rights because these were the most important that were highlighted through our findings. But it's important to note that virtually all fundamental rights may be impacted by the use of AI or in a way or another. So I cannot enter into details because we do not have the time and I already talked too much, but please have a look at our report and you will see that we also analyzed all the rights more in detail, the impact of AI system on other rights. To sum up, the use of AI should process data legally, not lead to unfair treatment, and be contestable. So what do we say in our reports? We said that any future regulation on AI need to be evidence-based. This is extremely important to be able to be applied on the use of AI. Include fundamental rights safeguards, so be rights-based, and ensure that it can be applied in practice. The full scope of fundamental rights with respect to AI should be taken into account. There should not be a focus on data protection and non-discrimination. Of course, these 2 rights are the ones that have a higher possibility of being impacted, but it's very important to keep in mind that all of them can be impacted. It's important to consider making prior impact assessments that would cover the full spectrum of fundamental rights. So the first presentation that we had this morning could be extremely useful for this. We've seen that in order to allow for an assessment of fundamental rights, there is not enough information about AI systems. So more information needs to be made available, and we need to enable external monitoring and human rights oversight by competent authorities. For those of you who had the chance to read the draft AI regulation, you will see that this is a very crucial topic because currently in the draft, in Article 43, if I remember correctly, there is only one case of use of AI system that would require external oversight. So this is why, in addition, in our recommendation, we call on the EU and on the member states to fund targeted research of potentially discriminatory impacts on the use of AI and algorithm, to provide more guidance on data protection when using AI, and to consider introducing a legal duty for public administration and private companies that are using AI systems to provide those seeking redress information about the operation of the AI systems. This was a long information. I'm sorry I talked too much, but thank you for listening to me. I am available for any questions. Please have a look at our report where you will find more information on our research and more detailed information on the different use cases that we looked into. And yeah, looking forward to our discussion today. Thank you.